state actually complied with the law. What do you make of this issue of the notes and an actual written statement not presented or attached with this typed statement?
Now, when one looks at it, and the defense is right, when there's a written statement that is taken down by the hand of a witness, that statement, if they retype it over because it might be illegible at the time when it's going to be used at trial, the state is obliged to make available that handwritten statement plus the typed version to the defense teams as well, because they're going to rely on that. And the witness, from the translations that we heard, he said that he made a statement, he wrote it out by himself, and he's a police officer, he could not have been confused. Now, I think here the judge is giving some protection to the prosecuting authority, and even going as far as to saying that the defense is saying or attacking the integrity of Mr. Baloyi. The thing for me was the defense just said, there is a statement, it might either be in the possession of the state or the witness itself, but between them, because they're on the same team, they should be actually giving, and he even go as far as saying that the state cannot, or the prosecutor cannot be the attorney for the witness. The prosecutor brought that witness there as his witness. He is the attorney for the public, for the citizens of this country. So the judge was sort of handling the prosecutor with nice, cozy gloves and trying to be harsh on the defense. And I think, for me, the judge should now, at some stage, realize that he's entering too much into the arena and let them actually put their arguments forth and not help the state out of prickly pears when it suits him.
Okay, let's take a listen at this moment, because Advocate Mnisi, and he's not the only one, Advocate Mshololo also wanted the court to replay the record so that the court could hear the witness actually saying that he indeed had a written statement. Let's take a listen at this.
I would therefore request, my lord, that the court grants us the indulgence and instruct the state to give us, as per this witness's testimony, the original, handwritten version of the statement. That would be my submission.
That dismissal was also meted out against Advocate Mshololo, the judge going as far as saying, well, I believe you. And so that record was not played out in court. Is that unusual? Because he relied on that piece of information to come to the conclusion that the state did nothing wrong.
Yeah, and for me, that is why I'm saying that the judge should now at some stage realize the judicial officer, he needs to be impartial and he needs to conduct, because this is something that can be prejudicial to the defense and to the accused persons. Why, if you say there's nothing that he comes to a conclusion to say that there is no handwritten statement, while the witness said that he made a handwritten statement. So what the witness saying, and then he even go as far to say that the credibility of the witness. Now I think already he's saying to us, looking at the trial, that that is a credible witness. He cannot make a credibility finding at that. It means that this accused in his eyes is already guilty, and for me, that is a sign of a judge that's not partial at this point in time. I'm very worried for the accused that I will see them getting found guilty and not being given a fair trial at this point in time, because what I'm seeing for the past couple of days, and I've been seeing this trend, when the defense normally raises an issue, the judge is quick to shut them down and to say, no, and it's overriding them. Instead of being cordial, this is officers of the court as well. Listen to them and actually allow them to speak, not just cut them off, because when the prosecutor speaks, he's not being cut off, he's being given ample time to elaborate and canvass his points. So for me, I'm worried about how the judge is handling. People might say, yes, he's getting to the point, the previous judge, Maumela, was not, but I'm also seeing some prejudice somewhere lurking there from the judge towards the defense and how they cross-examine and put their defense across, and they are being limited actually to canvass their defense completely with the state witnesses.
It's also unusual, Elton Hart, that the judge had a judgment. It was quite lengthy, typed out, highlighted. There were some notes that were made on it before he could even hear from the witness who came back from KwaZulu-Natal. He didn't even know whether he would have these notes or not have these notes. Is that unusual?
That is highly unusual. How can a judge have a typed out version of a judgment, not even having heard to see, did you find the notes? Did you search? to do a preliminary inquiry. For me, that screams impartiality from the judge's side. And I don't want to talk about the judge's integrity and stuff like that, but for me, those little things, it builds up, and to say that you are not giving the accused a fair chance and actually putting their defense, and actually now the accused must build a defense as the case progresses, as the prosecutor decide. Who knows, tomorrow the prosecutor might come with another witness that he says, because of security reasons, it was not disclosed, and now they need to come and answer to that evidence that will be placed on the table. That's not a fair trial to me. Definitely not.
You speak of not a fair trial. Let's hear what Advocate Nshololo on behalf of accused number 5 had to say.
I'm referring to the type 1.
Oh, the type statement,
yes.
not the written statement. Okay.
Yes, my lord. I'm referring to the type 1. I want to address his lordship regarding the prejudice. Because...
No, you know what? You're putting the cart before the wagon, or the horses before the cart and the wagon. We are here conducting an inquiry whether there is a written statement. That's what this case is, this inquiry is about. I've given you the leeway to compare what is in this written statement and what is supposed to be in the, what is in the type statement as opposed to what should be in the written statement. You can't do that. Logically you can't do that, because we only have one statement in court at the moment. Is that not so?
One submission, my
lord.
Yes, just one. My lord, my submission is that accused number 5 will suffer prejudice if he continues cross-examination without having the original statement of this statement.
You are correct. That's why this court went out of his way to make an order that this witness should go and fetch all those statements or communications or notes, because Mr. Baloyi says he does not have a written statement made by this witness. And I'm aware of the prejudice. That's why this court, in evening the playing fields, made that order.
Elton Hart, what options are available for the defense should they feel that their clients are not receiving a fair trial, just using this particular witness and events of the past few days?
Simple. You ask for recusal of the judge, because that's the only other option that... And the thing is, like the judge himself, in listening to that clip, he's confusing himself to say that I'm giving you an opportunity to refer to the type statement and the written statement. How can they compare something that they haven't seen? So he must also sometimes listen to what the defense team is putting on the table before interjecting. He must give them a fair chance. They are officers, they are professionals. He must treat them as such in the court. And this notion that judges think that they are the law should stop. Because for me, it's like you don't want to give the defense a time to actually explain. While people are facing imprisonment, they can face long imprisonments, and you're not giving them a fair chance. Yes, here in this instance, and that's why our constitution is written in a specific way, that we should err on the side of caution. Because now suddenly, not listening to the defense, these people can be sentenced to prison for something that they didn't do, because their defense teams was not given a proper chance to. So the state was supposed to say, let's call the investigating officer and find out from him. Did he actually take a handwritten statement from this, which was then later transcribed into a type version? Because from what did they type? Did the witness sit with a typist to actually type up the statement? So from what did they type that statement? Because they need to bring clarity, say, okay, he sat with his notes and then he dictated to me and I typed the statement. But if they say I received a handwritten statement and I had to retype it, then it means that at some stage a handwritten statement existed which was commissioned, and that statement is needed.
At some point there was a document that was doing the rounds where the defense saw it and the judge self saw it from the witness. That's where we'll leave it for now. Legal analyst Elton Hart, thank you very much for your time.